Okay, good afternoon, everybody. This is the English presentation of Allies All Around, finding allies if you are in a custody dispute involving a special needs child. All right, so starting off in terms of basic concepts. By the way, was anyone here for my presentation last year? I think you were sitting in the same chair last year. All right, some basic concepts about custody. In family law, custody is determined by a judge, not a jury. That judge may have a law degree. It's not required. They need to be appointed by a governor or elected by you as voters. Other than that, they don't necessarily have qualifications for the job that they are doing. So, are we good? Okay. All right. So, what does that mean? A lot of people think, all right, that's the judge. Shouldn't they know something? And if they're in the family law department, shouldn't they know something about family law? I will be honest with you, how family law judges are appointed or selected for their particular assignments is a mystery to me. It is not part of this presentation to tell you how that happens, only to let you know that it is not some sort of vetting process that creates a situation where you have an ideal person who knows about family law. They may learn on the job, they may learn by experience, but here's another issue, they rotate. Some family law judges don't serve a year before they go to the criminal department or some other department. So add to that you're not going to have their attention for very long. There are hearings of different types and flavors. Your initial hearing may be an emergency hearing called an ex parte hearing. That may last 5 minutes. Your regular hearing may last 20 minutes to 40 minutes. And then a full trial may have a much longer duration, and we'll talk more about that. And yet, these people have decision-making authority. Because they're dealing with lots and lots of cases, they apply certain, what I'll call razors, formulae to get through problem solving and decision-making quickly and easily without giving things too much thought. Now, already you have a situation that's hostile to your situation, which is special needs. That's not a situation where it can be done without too much thought. There's a ton of information. Data has been accumulated for years. And if you have a conflict with another parent as to what needs to be done for your child, then sifting through who is right in the limited time with the limited expertise, well, you get the picture. That's why we're talking today. So, first of all, let me tell you, now that I've painted this bleak picture, it can be done. There is hope. And it starts with doing everything right. So here's how you start. So first of all, in terms of allies, I started out with a list, as I said, that had dozens of people on it. But no list is good and no team is any good without you. So the first thing is, have in mind how you're going to keep yourself together. Generally, special needs parents, even in intact families or even with non-oppositional co-parents, are exhausted and feel tired all the time. And that should already be a warning to you, because the fact that you are investing so much in the needs of your child, and then add to that now you have to coordinate the team for the benefit of your child, maybe have to deal with a school it is not necessarily willing to give all the services that your child is entitled to, and then add to that, oh my gosh, the other parent with whom you decided to have this child wants to prove that this child is fine, that this child has no special needs, the child needs no services. And what is the agenda of this other parent? Usually, well, if the child's fine, then both parents are equally good, and the judge really shouldn't pay any particular attention to this case and should treat it like every other case. And we're now back full circle. Judges do have a formula in mind as to how they would like to treat every case. They would like to start with the basic idea that children benefit from both parents, and the more they can facilitate the involvement of both parents, the better, and in that case, they're winners. They miss the point that the issue is not relationship with both parents, but decision making, because decisions have to be made sometimes daily, but at least weekly, about therapies, about education, and about services. And if you have people at odds about those things, or people who need constant explanation, that delays things for weeks, or if there's opposition that prevents things from happening at all, it's to the detriment of the child. A judge, well, here's a common mistake. Let me start with a common mistake. Common mistake is going into the court and in the few minutes that you have trying to prove that you are a better parent than the other parent, in the hopes that what the judge is going to do is say, well, I agree, you're the better parent, you have custody. The reason why that doesn't work is because, remember, the judges are inundated by cases. They're looking for the easiest solution. The easiest solution is to tell both people that they win. You both win. Joint custody, share alike. So you go in there and you prove that you're 3 times the parent that the other parent is, and you say, why don't I win? I'm 3 times. This is a neglectful person who's never home, leaves the kid with caretakers, doesn't know anything about special needs. I am 4 times the parent that other parent is. That parent is, and so here's what the judge is thinking. 4 times the parent, 1 time the parent, 4 plus 1 is 5, joint custody, because 5 is better than 4. I'm not kidding. I'm being dramatic in my demonstration, but that's what you have to get past. So one of the things we're going to talk about in this presentation is how you show the court the fundamental, primary, basic thing, which is that they have to make a decision at all. Right? They have the title judge. You were thinking judge. They're going to pick. They're going to decide. They're going to choose. They're not unless you prove to them that that's what they have to do. So you literally have to put on a case before the case. Before you even get to who is the better parent, you have to convince the judge, I have to pick a parent. Now here is the good news. The courts are trained to some degree to have to do that under certain circumstances. Let me tell you what those circumstances are. Everyone's heard about no-fault divorce in California, I hope. Okay? Now, not everyone's dealing with divorce. You can make kids without marriage. Don't tell anybody, but it's true. But in general, we're told that you're not supposed to make decisions on fault, but we have built fault back into the custody system. So the custody fault system is this: domestic violence, abuse of alcohol, abuse of drugs, abuse of the child, and that can be physical, sexual. Psychological is a heck of a lot harder to prove, but it does fit within that. So if you can prove any of those things be more probable than not, the court says, aha, there is a presumption, Family Code Section 3044, you don't have to write that down, but there it is, 3044. Creates a presumption that someone who's engaged in that sort of abuse, there's a presumption that that person should not have any kind of custody. With alcohol, the court's supposed to consider that, and that's like fault, right? Ma'am, you're a drunk, I'm going to give custody over here. Or you're using drugs, the kid's tested positive because whatever drug you were using showed up in the child, I'm going to do custody. All right, so the court is trained in that. So the court, it's not that the court will never decide, the court's persuaded under those circumstances to decide because it's written in the statute. Under these circumstances, written, you shall decide. Special needs is not on that list. In the rules regarding child custody evaluators, which we're going to talk about in a little while, it actually talks about all the qualifications child custody evaluators must have. A child custody evaluator is usually a psychologist who's appointed by the court to help the court make decisions. And supposedly because they have PhD after their name, they're going to know something about your child and be able to make recommendations. As I will elaborate further later, this may sound like this is all coming attractions. There's a lot of coming attractions. Most of the psychologists do not qualify for anything other than custody itself. And in there, they're very qualified. So what the heck do I mean by that? They understand relationships between parents that are good relationships, that are dysfunctional relationships, how that interferes with communication and co-parenting. They understand about relationships between children and their parents. They know how you can have different attachment bonds. They might be secure, they might be anxious, they might be dysfunctional or functional in many different ways. All of those things are very, very important things and are not the elephant in the room, which is here we have a child with special needs. And someone needs to be able to make decisions. So as expert as these people are and as used to using these people as the court might be, ultimately what they have to say may not apply to you. And why did that happen? Well, if you look right in the rules, which is in the CRC 5.220 and beyond, don't have to write that down either, it actually says what their qualifications are and what they have to know. And they have to be aware of things like drug abuse, and alcohol abuse and domestic violence and sexual abuse. All of that is required. And thankfully, guess what? Special needs actually is in that list. And what it says is they have to have an awareness that of those issues. Now, what does that mean? It doesn't mean anything. It means, hey, I understand you have a child with special needs. Okay, and now what? Literally, there's no rule that governs what that means for the evaluator, and so by extension, there is no rule as to what that means for the court. The court is bound by one tenet in making its decisions, which is best interest of the child. And it has statutes that frequent and continuing contact with both parents is good. There is no presumption for joint legal custody, but as I said, that's an easier decision to make than to pick. So you're going to have to prove, because you have no statute to back it up, that it's in the best interest of the child for no statutory reason other than it's a fact that one parent is going to have to decide. And how are you going to prove that? I'll tell you, I promise. Okay, so back to where we start. Start with you. So what does that mean, start with you? If you're feeling exhausted, that's your first line of discussion, your first line of defense. You're going to need rest, which means you need help. That's what respite care is for, that's what friends are for, that's what family's for. People on your side that won't let you get exhausted, that won't let you overcommit or overinvest your time and your precious energy capital into what you're doing. Parents who are involved with special needs kids are already at a disadvantage because until your child is perfectly safe and competent and doing well, you don't feel like you're doing enough. You always feel like you need to do more. You always feel like you're falling short. And I'm sorry, because I know what that feels like. And unfortunately, you have a limited amount of charge in your battery. And like they say on airplanes, you got to put your oxygen mask on first. You got to be taking care of yourself, and you got to have people around you that will be watching you, making sure you're not overdoing it, and who will stand up to you when you say, you don't understand, I have to do more because the child still needs whatever. It's like, yeah, but if you're not together, everything is lost. So start with taking care of yourself. That means eating right, getting enough exercise, making sure you do social things with people that you have something in common with. And make sure you're constantly socially engaged. Being involved with your special needs child can also be very isolating. Parents need adult contact, and one of the things I hear from parents a lot is, I love my child, I love kids in general, but sometimes I just need an adult conversation. So I'm spending a little bit of time on this because honestly, I'm going to talk to you about 40-odd other people, but this is the most important person. This is it. This is where everything rises and falls. Your judgment is what counts. You can have the best professionals in the world. Ultimately, you're team captain. You coordinate these professionals. You're the person who decides which advice makes sense, because different professionals involved in different fields are going to see things from different perspectives, but you know your child. All right, after we get to you, I've already kind of mentioned this, you have your inner circle, right? Your family, your friends, communication. Your community, church, congregation, your therapist. Yes, please do not be embarrassed to go to a therapist if you feel you need one. I'll give you a quick statistic. They have found that people who need emotional support, which is most of us, especially if we're in times of stress, people who go to therapists and people who rely on religious congregations or something similar, an activity that has aspects of religion, even if they don't worship a God, but they have a common purpose. It could be educational, it could be Peace Corps, whatever it is. Their odds of success psychologically are the same. That community support and therapeutic support have equal batting averages for helping people. Now, how about that? Now, the same survey found out that if you have both, you do even better. Okay. So that's why I put all that up there. All right, in terms of action and support, other parents, people who know what you're going through, I'm so grateful to see that there's a lot, get to know each other at some point, because you guys all have a common experience. This particular lecture is very focused, right? I'm not Seth Schwartz, who's right now lecturing to 110 people because he's an education attorney. Everybody has to deal with IEPs, everyone has to deal with schools, everyone has to deal with the possibility of due process. I'm never going to have 110 people in this room. They still have me come back every year because there are still a select number of people who are in custody disputes. So you want other parents who are going through what you're going through so that you know you're not crazy. Because there's plenty of people who are going to tell you you're crazy. You're a helicopter parent, you're overprotective, you're undermining the stability of your child who needs to rely on him or herself. Other parents, school activists. Now what does that mean? There's some parents that aren't just people you know who are peers. There's some parents who've self-appointed become advocates for a particular niche issue. It may be your issue. So if you find a parent like that, become that parent's friend. Because they're motivated enough, they're not going to charge you any money. Their payment is in helping you. All right, I put movers. Now what does that mean? Sometimes you'll find that you just have to leave. You're in a school district that's bad. You'll never get anywhere with them without terrible, terrible effort. You may find that you have to go somewhere else and get into another school district. Don't be afraid to do whatever you need to do. Domestic violence support. Special needs kids often are in families that break apart over the stresses that are involved in their care. That's true. A lot of you will have experienced that your relationships were actually seeming to do quite well until this particular challenging child came into your life. Okay, that's not everybody's story, but it is a fairly common story. So, and sometimes the reaction of the other person who is less involved, more in denial, can be quite strong. It could even be violent. It may even lead to domestic violence restraining orders. That makes you a member of another community that's not just the special needs community, but one that's of more general application, having to do with a situation where someone who was a peer and a support and a help is now a source of disrespect and violence. So these people can help you keep yourself together, and as I said, that's of paramount importance. Sorry, this is not a touch screen. All right. I'm going to get right into this because this is the big issue for everybody, and that's money. We started with the allies that are free, but there are a bunch of allies that are very helpful that are professional, and we're going to get into those. And money, whether you like it or not, is a measure. Just like a meter stick is a measure and a scale is a measure, they measure in pounds, right? Money is a measure of your influence on other people. It's as simple as that. Now you can influence people in ways that's not measured in money, but money is an absolute measure of your influence on people. If you have a lot of it, you might not even have to spend a lot of it, right? Millionaires walk into bars and get free drinks because they're known and popular, and right? Okay. So everyone needs it, and you should not be too proud to be asking for it. Everyone's somewhere at a point in an arc in their life, right? And you're already programmed, because I can tell because you're here. You want to help, right? You have a child you want to help, but you're generally of a personality that is helpful. So for people like you, it's very difficult to say, I need help. I need someone to just help me. Especially in a situation like this where your circumstances may not require hundreds, it may require thousands, it may require tens of thousands, it could reach hundreds of thousands of dollars in terms of what it would take to do what you need to do. So the good news is we live in the richest country in the world and money exists. So when I talked about relying on your friends and family for support, that's good. If they have money, they should give it to you. If you're worried about taking charity, tell them it's a loan that you'll pay back at 5% interest when you can. That'll help your pride. Right? It might be 20 years from now, but it's your friends and your family, and they'll understand. They also may help you with fundraising, and funds can be raised in many ways. And in fact, there are fundraising sites. I listed a few, but this is by no means an exhaustive list. I talked about Kickstarter and GoFundMe, and you can do it through Facebook with email blasts. There's a thing called SnapRaise. You can actually get a professional to help you. There's actually people who will help you develop a video where you can explain your circumstances and promote it. And then there's people who will loosen their purse strings for you. And you may even have heard on the news how money gets raised instantly for people who need it. Some cemetery is desecrated. People are touched by that. They generate money for that. Your circumstances are at their very core and by their very nature sympathetic. And there are people out there who either understand your position, are in your position, or were in your position, people who are like you now but maybe 20 years down the line who now are in a much better place and want to now give back to the people who helped them. Those people exist now. So don't be afraid to do that. All right, the other thing is No Low Press. I really love them because they're people designed to help people who don't have attorneys. And they can send you a book or give you an online assistance in setting up your own corporation. You can set up a non-profit foundation that is maybe just to help your kid or maybe to help kids like yours and others, and you can name it after your child or somebody else. But these are just mechanisms that exist. I could make a whole speech on just the raising of money. My main purpose now is just to raise your awareness that you shouldn't just think, oh, I don't have money. Or I don't have, I understand what you're saying, but I don't have time to go after that money. All right, well, if you don't, someone else who loves you does. That's what you do. You start with, you're the captain of the team. If you don't have the time and you don't, and you're used to doing everything yourself, get out of that habit. Find the people that will help you do different things, that will do it because they love you. Okay. These people can help or hurt, right? That's your experience. People at the school, right? They're there to help your kid. They're there to help your kid for free because everyone's entitled to a free and appropriate public education, right? Everyone knows what FAPE is. If you didn't before, you just heard it. And people often have gotten into these professions that are listed here because that's what they want to do. They want to educate kids. They want to help kids, right? They had that urge. And yet, once they got to public schooling, they learned all about politics, and they learned all about budgets, and they all learned all about authority. And suddenly, they learned to be resistant to giving kids who really have needs what they need. And some of you may have encountered that about where you have a child that has certain needs, and you might even have like a teacher who knows what your kid needs and is recommending it privately to you, but when it comes time to the IEP, they're not speaking up. And then the case manager says, no, that's not necessary, and where were you? Why aren't you saying anything? So some of you have that experience. My first caution is, regardless of what difficulties you might have with them, and maybe you have none, maybe you're lucky and they're great and they bend over backwards and they help your child, in which case I don't have much more to say about that. You already know these are your friends. If they don't seem to be helpful, don't pick a fight with them, don't pick a war with them. There are ways to get what your child needs in a way that is non-adversarial, even if there is some amount of conflict in the resolution. And I'm going to talk about that in a moment. The reason why you don't want to alienate these people is in your custody trial, when we get there, these people will be witnesses. Because also at the IEP is the opposing party who has a vested interest in terminating services and treating the child as though the child has no needs. And if that parent manages to convince some of these parties at the school, they'll ally with that person against you, and not only will your child not get services, but we also have these witnesses who will testify against you. All right, so what do? I said don't pick a fight with them. You have to put an educational team of your own. And unfortunately, this is where money comes in, because generally there's no public money for this. The last exception is the educational attorney. That person's last on the list. Those people will help you for free if you have a case. And that's because ultimately if they're right and the district is wrong, the district pays for it. But generally, you cannot jump straight to the educational attorney. You have to take some steps initially. So the first person you actually need is the educational consultant, also called the advocate. And you want to pick that advocate well, because anyone can be an advocate. Many of you could be advocates. There's no certification program for advocates. There is no licensure for advocates. Anyone who wants to advocate may advocate. And a lot of advocates are just parents who've been through it. They charge less, and they aren't ineffective. But the one thing that they may not be able to offer as well as some educational consultants with a lot of letters after their name who might be former principals or former superintendents or former special ed teachers or all three, and I'm thinking of one person in mind who is. And they charge a little bit, although they're much more efficient. They get a lot done in a lot fewer hours because they often walk into these meetings. They often already know all these school professionals, right? They used to work with them. Hey, remember when I was your principal? Now I'm this person's education consultant. This person often can resolve your issue in there without a fight. This person, without being confrontational and threatening due process, may actually get these school personnel to move over to your side. The opposing party seeing this, first thing that person may want to do is try to fire your consultant. I've had that happen in a number of cases. And some consultants are gun shy and they'll let themselves be fired by the other party. So the person you want needs to be legally savvy enough to know that the other person has no right to fire anyone that you care to bring with you as an educational consultant, and who is willing to stand up to that person and say, hey, I'm just here to offer my perspective. I have no status as a legal representative, but I am hired by this parent. I'm entitled to be here. School's going to let that person be there. And the fact that the other parent took a stand to try to get rid of your educational consultant, well, the judge will hear about that someday. And the other parent will have to justify that someday. So the fact that that person tried that, stick a pin in that. That might be helpful for you later. It might feel real frustrating now, but later on you may have the opportunity to turn that to your advantage. All right, education consultant placement. That's different from your advocate. That's someone who you can spend a little bit of money on and who will tell you where your child might need to go if your child cannot stay in the regular public school. And you would think that the public school would know a lot about other placements, but generally they really don't. And so often you are forced to bring in your own person who's extremely expert, hopefully also very diplomatically savvy, who can offer suggestions, some advice. And ultimately what you're trying to do is, if you're talking about this other placement, to get the district to pay for it. An educational psychologist. School has its own psychologist, as you saw, but you may not agree with their conclusions. And you may ask for your own independent evaluation, an IEE. And you may wonder why I'm bringing up all these people that you may already know about in the education side. And I've already kind of hinted at it, because these people are not only grooming the school people as your witnesses, but they also may be your witnesses in court later, and they're going to know about your child, and they're going to be able to tell the judge about your child because they conducted the assessments or did the reviews or the evaluations or offered suggestions. Therapist, your child may have individual therapy. That's very helpful at the IEP. It's also a very helpful witness. Occupational therapist. Now, why are these people great? They keep data. Oh, they keep lots of data. They, for however many years these people are with your child, they will keep all those records forever because they're data driven. They have to show whatever progress in the particular skills. And data is great for courts. It's called evidence there. Speech and language. Socializing your child often is a challenge because kids are kids. They're developing their relationships based on peer advantage. They're attracted to other kids who look successful or popular or cool. Your kid may not be so successful, popular, or cool. We happen to be lucky to live in an age where quirky can also be cool. And so often special needs kids can be popular if you're lucky. But where they have difficulties and challenges, speech and language is awesome for that. And to be able to explain why that's important, well, that's There's your great witness. Because a judge is not going to understand that. I mean, the judge understands popular and unpopular, but the judge is not going to understand why that's a custody issue, why that's a decision-making issue, why that's something that a professional can deal with. And then there will be a professional who says, oh no, that is, there's whole careers built on that very issue, and I'm in that career, and let me tell you what it means. Optometry, a lot of your kids may have visual motor issues that are very difficult to explain to lay people, but these people have an appreciation of it and can explain it. Therapeutic counselor, and then finally, the educational attorney. All right, so the educational attorney, as I said, thankfully is free. This is the person whom you hire when the school is just intransigent and isn't going to give you what you need. And this is the person that you bring in who may take it to due process to the point where the district may be fighting the issue, and if they lose, your attorney's paid for, and there's a court order and you get what you need. But this educational consultant and an advocate, I think you guys understand why having those on your education team and an IEP are good. But even if you're not faced with issues in the school that require advocacy, even if you're not faced with issues in the school that require an attorney for due process, it is still a very good idea to have these people as witnesses on your legal team. And you're probably wondering why. Well, I don't have due process. I don't need an advocate. The school's cooperating fine. Why do I need them on my legal team? And in fact, what would I even have them say? Right? I didn't have them do anything. They weren't at an IEP. I didn't need them for an IEP. What are they going to say? So now we go back to what I told you in the beginning. The first thing you have to convince a judge is that they have to choose at all. So you put on 2 experts. In fact, 3. There's a person that I will call a blue-collar special needs expert that will come up in a different slide. So there's really 3 experts. Your blue-collar, your educational attorney, and your advocate. And they all get up there, and your attorney or you or the opposing attorney will ask, well, do you know this child? I don't know who this child is. Did you ever do any work with this child? I never did any work with this child. No. Why are you here? Well, to answer your questions. I don't have any questions. Well, yes, but I think this person has some questions for me. So what questions are you going to ask, or what questions is your attorney going to ask? Why is that person there? And they're going to ask questions like this. Are you an education consultant? Yes, I am. How many years have you been doing this? 150. That's a long time. What else did you do before you were an education consultant? Well, I was superintendent of Vista Schools, and before that I was principal over at San Diego, and before that I was special ed over in Fallbrook, and before that I was special ed also in San Diego, director, and then before that I was just a special ed teacher for 25 years. So do you feel that you're an expert in these things? Yeah, I kind of do. All right. Let's talk about circumstances where decisions have to be made, and they will talk very well about all the areas where parents make decisions. And then they'll be asked, well, what happens if a decision has to be made and the school doesn't cooperate? What happens then? Well, then you have to go to due process. Oh, okay. And what happens if the other parent doesn't agree? Well, then we can't take the case. If the parents don't agree, the school will just take advantage of that and nothing will happen. And while one parent's trying to promote a legal position in due process, the other parent's undermining it. We can't take that case. We can't do it. So now we have a person who says, with hypothetical questions, knowing nothing about your kid, why it is that sometimes you have to have one person deciding. What kind of decisions have to be made? Well, sometimes you have to decide if a particular occupational therapy is correct, and how often, and how frequent, and where it's going to happen. And if you have another parent who doesn't understand that or opposes that, and you have to explain that, then occupational therapy can be delayed months, years. Is early, intense intervention important for special needs kids? Yes, it's very, very, very important. Do delays cause damage to kids? Absolutely. Okay, all the literature says so. So what this attorney, what the education advocate, and the blue-collar person will say, and maybe you'll even put an educational psychologist on, same thing. They may not know your kid. Now, if they know your kid, that's fine too. But even if they don't know your kid, their main purpose up there is to explain why under these circumstances you can't have a two-headed monster. The person who has involved him or herself in this kid's life, that person just needs to make those decisions. And it doesn't do the kid any good to have a committee or a conference doing it. And the judge may say, well, what about something like a parent coordinator? We'll get to that. All right, direct support. Okay. Those of you who've dealt with Regional Center probably know that it can be of great assistance. They can offer a lot of services. They can be a source of funds and a source of professional assistance. Sometimes they're more assistance earlier and of less assistance later, because there might be a reevaluation. Regional Center people, same thing as schools. I mean, there's a lot of professionals that are in it. They often want to help, but they also are bound by budgets. They are also constrained by pretty strict guidelines. So, for example, if your child was diagnosed with autism before age 3, when your child was nonverbal, they may have qualified under the code 299 autism. Later on, when they get reevaluated, they discover they no longer qualify. And you'll get this report from an educational psychologist at Regional Center that your child is not autistic. Okay? And this is just an example, because the special needs of your child may be different. It may not be autism, although that's a super common one. Does the judge understand that this diagnosis now that your child is no longer autistic mean that your child was cured of autism? Does it mean that maybe there was a misdiagnosis initially and your child never had autism? Well, the court doesn't know. All the court knows is, well, it says no autism, so I guess it's not a problem. You need someone to explain to the court that there's a difference between the autism spectrum and classic autism, and that Regional Center is not really a diagnosing body. They're not a hospital. They're there to provide services or not provide services. The closest thing they are to is maybe like insurance or like a government grant, something of that nature. And so what they conclude is something they conclude for their purposes, not yours, right? Not for the child's. They're deciding whether to throw money at you. And what they say with their diagnosis is, this child doesn't qualify for our services. Your opposing parent will run with that. Will run with that. Look, judge, the child is cured. You might as well just give us both custody because we don't have to do anything anymore. This child needs no support anymore. So you need an expert who will explain to the court that what Regional Center says is actually, to some large degree, irrelevant. It looks official. The person who signs off on the report says PhD, and it just doesn't matter because their purpose was not to help the child. It was not to help the child. It was to determine whether the child was eligible for services or grants from this particular body. That's it. And as long as you understand, Your Honor, what the purpose of this report is, you can take it in the proper context. It does not mean that our child is cured. Hallelujah. I talked about the Regional Center case manager, psychologist, everything I said, their services. It all falls under the same thing. With regards to ADA legal services, that has to do with accommodations for your child for having special needs. If Regional Center's on your side, all the better. I've just talked about what happens when Regional Center is not on your side and how the other party might exploit it and how you can be prepared for that. Insurance professional as well. So a lot of people, I suspect even in this room, have a child who no longer qualifies for Regional Center services and yet is covered under insurance. It happens. And someone made that decision within the insurance, so great. And now you have a witness. All right. With regards to other people who would be great witnesses as well as great internal support for your child, people who provide ABA or DIR or social coaches, whatever your child needs in home. I happen to pick a bunch of stuff that has to do with autism because that's very common in the classes I teach. But whatever special needs your child has, a lot of them require some sort of in-home support, maybe an OT, an occupational therapist that comes in. They take data, and then they're awesome for that. All right, and then pediatric hospital, if your child was ever evaluated in a hospital and provided services, then we have a source of witnesses there. These are people who provide direct support. The great thing about the witnesses in general who will talk about what support a child needs and about decisions that are made is unlike, well, let me see if I can categorize this in a way that will show how you can step ahead even in the face of opposition. I've already talked about how if you have the school people against you, the opposing party is going to bring them to court and they're going to talk about how the kid doesn't need services, you're overblown and over-exaggerating and you're a helicopter parent. That's their pitch. If Regional Center stopped offering services, they're going to do the same. They're going to call those people as witnesses, and they're going to get them against you. And then what you have is a battle of experts. You have them, and then you have your experts who say, I did my own independent evaluation. Yes, the child does still have needs. Okay, and then you have your education people who explain why schools don't always offer services even if they're needed because they have other constraints. Regional Center, the same. Here's where it gets cool. Here's where it gets super, super cool. The court's trying to figure out, well, if the school and regional center are saying this, and this parent's personal paid consultants, right, hired guns, are saying this, how do I know who's telling the truth? I'm actually inclined to listen to these public entities. And that's when you need, or that's when it helps when you have an educational consultant or an advocate or a blue-collar person in your field who can say, Judge, let me give you the overview. And by the way, I don't know this child. I'm just telling you this is the way it is overall. The way it is overall, these people are in politics and budgets. These people are hired to help people. They're not hired to give false reports. I mean, they may get money, but they're not going to lie about what their tests show. And this kind of dynamic exists all the time. And because of that, navigating that requires agility, requires an understanding of it, and requires an interest. And if you have someone who's a denier and who's willing to deny or who's willing to believe every single person that says everything is fine and who's not willing to actually get professional advice and lay out the money to do it, well, that person's going to impede proper decisions, and the person who does the education is going to do the right decisions. So it all boils down to showing the court they have to choose and then showing them why they have to choose you. So although you have all these witnesses, all those witnesses are going to be confusing to the judge as to which to pick. You need an overall witness who guides the judge, who's Virgil in Dante's Inferno and says, all right, you listen to that person because their motivation is their craft. You listen to this person left because their motivation is budgets and politics. And the judge won't know that unless someone tells that person. All right, so who coordinates the show? By now you're starting to get the idea that this is a lot like a show for the judge. So a show is one way of looking at it, another way is class. We have a class with one student, and that student is the judge, and the judge is there to learn. Judge is hearing all of this interesting stuff for the first time. Judge had a whole lot of assumptions before about who was on your kid's side and who wasn't. And so who's going to put on the class and who's going to invite the speakers and who's going to present this seminar? If you can get the funds together, always best to have an attorney who understands the legal system. And that attorney should not be working alone. That attorney should have a team of people either in-house or affiliated to organize your case. Now, by the way, the principles I'm going to give you apply whether or not you have an attorney, and if you are forced to do it with yourself and your family and your friends, you'll be able to apply these principles. But obviously, an attorney has some inherent advantages. I added in that list what's called an attorney assistant. That's nothing more than the person who does your documents. That person may or may not have any particular understanding of special needs, but that person knows how to prepare documents and knows how to turn your words into declarations that the court will read. The court has these services for free. There's a thing called facilitator. You can wait in line in the morning at 7:30 in the morning, and they'll open up the doors at 8, and they'll help you fill out those forms. They don't know anything about special needs either, and they don't know anything about your story. They're not covered by malpractice. They don't represent you, but they do know how to help check boxes and fill in things. And if you're forced to use them, then that's what you have. But if you're fortunate, you'll have someone in-house in your own attorney's office. All right, a paralegal document preparer. If you can't afford an attorney and you don't want to wait at 7:30 in the morning and you want someone at the mid-range between free and expert, there are people out there who can prepare documents for you. Once again, they won't know anything about your story or special needs or how to win your case, but at least your forms will be adequate to get into court and in front of the judge. Court facilitator, I jumped ahead. That's what I was talking about, where you wait at 7:30 in the morning. Blue-collar expert, as I say, that's somebody without credentials, but who nevertheless has a good overview of the arc of your case. So, for example, one example of someone I've used before is Chantal Cecile Kira. She is the head of Autism College. So if you have a case on autism, she's a person who has no degrees but is paid tens of thousands of dollars to lecture all over the world because she has an experience and a speaking style and she has something to say. And the last case in which I used her, the judge said that out of all the witnesses I put on, she was actually the best and the one that influenced him the most. So, and it's always good to have a chorus of voices rather than just one person, if you can afford it. The blue-collar experts, fortunately, actually often cost less than your psychologists, than your educational consultants, and your advocates. So, but like I said, it's good to have a chorus of voices. Parent coach. All right, I cannot emphasize this enough. What's a parent coach? If your family law attorney doesn't have one, you find one. And if you can't find or afford one, then you find a friend or a family member that you trust who knows something about the court system, who has been through the family law court system successfully and knows what a judge is looking for in terms of communications between you and the other parent. I hadn't touched that before. You have to communicate with this other parent all the time. Courts expect it. A lot of times you know dang well that what you're saying is falling on deaf ears. A lot of times you know what they're telling you is completely disingenuous. Right? They're trying to feign interest in something that never interested them before. Sometimes you just want to answer sarcastically, vulgarly. Here's what this parent coach is for. This parent coach is to see what your communications are, not to edit your content. I mean, if you want to say there's a doctor's appointment on March 3rd with this doctor for this purpose, great. That won't be changed. But what the parent coach will do is take your message and say, this is how to write it in a way that the judge will really, really like, and let this other parent write whatever they're going to write that will sink their case. Now, by the way, there is transparency in this regard, right? No one goes to court and say, well, you know, that parent hired a parent coach. This isn't the authentic parent. The real parent is crazy and insane. And if it weren't for this parent coach, Your Honor, the communications wouldn't look so good. Okay? Let me tell you what the response to that is. Your Honor, my client hired a parent coach. It's not because my client is inauthentic. It's because my client is interested in having communications that are effective and recognizes that my client has buttons that opposing party knows how to push. Surprise, surprise. They used to be together, they had a child together, and the other party knows exactly how to push this party's buttons. Exactly. So my client, knowing that, has hired someone. That doesn't make these communications inauthentic, because when my client hit send, that party received. And that communication went. It's not a phony communication, it's a real communication. But it's one that's thoughtful and was assisted by a professional that my client chose for that purpose. And it wasn't just to look good to Your Honor. And I say just because, yes, we do want to look good to Your Honor. We're not going to hide that. Your Honor makes all the decisions here, and we need to be mindful of what it is that you're looking for. So that's not a sin. So what am I pointing out here? What I'm pointing out is if your attorney is worth his or her salt, it's not someone who is conspiratorial. It's not someone who plays tricks. Everything transparent, everything out in the open, that's actually how you win. Let the other person engage in conspiracies. Let the other person play games. Everything you do is out in the open, right? And you know that, Your Honor, my client knows that this other party wants to prove that my client is crazy. By the way, it's true. And that person drove my client crazy. But my client has built the crazy into my client's plan to make sure that the child nevertheless is not affected by the crazy and gets the best services possible. Okay? My client's not worried about the war. My client wants to end the war. My client has hired people to end the war, to make sure that my client's communications are not setting off bad reactions in the other person. So let me just say, I'm actually concerned that this person thinks that's a bad thing. Okay? So I spent a lot of time on the parent coach. But the parent coach is the day-to-day. You're not going to be in court every day. Your communications of every day will eventually get to court. So it'll be as if you were there every day, but you're not. So what happens day-to-day is what you and your parent coach have to deal with. If you can't afford a parent coach, then find a friend you trust that you don't mind running these messages by so that someone whose buttons will not be pushed. You have a question?
Do you have information for all of these resources, like a parent coach?
I have one who's in-house. I happen to be married to one. So the answer is yes. So by the way, so the question is, do I actually have resources for all these people? And the answer is yes. So one of the conditions of my presentation is that I don't do self-promotion, right? This is not an ad for my firm. Having said that, it is not dishonest to say that as far as I know, our firm is the only one that does all these things. Okay? It is my hope, and I'm not kidding because there's plenty of business out there and I'm not looking to be a monopolist. It is my hope that after this presentation that I will be getting together with other professionals, and I actually got invited by presiding judge. The presiding judge has since rotated, so we'll see if the invitation is still good, but it's probably is. And I want to put on a much bigger symposium that includes members of the bench, members of the bar, so that we can get people focused and interested in this subject. Because you see that what I'm saying is of generic application, right? If we have people who are deniers and they hear this information that I'm giving, at the very least they're going to want to look like they're not deniers, right? So they want to get with the program. Okay, so my goal will be that I won't be the only attorney out there that does these things and who knows how to use a parent coach. A lot of attorneys are going to be afraid of a parent coach. They're going to say, well, if they know my client's coach, they're going to think my client's a phony. It's like, you just heard what I said. I'm sure it made all kinds of sense to you, right? It's not phony. It's coached. That's why they're called coaches. It's still my message. It's just repackaged so it doesn't anger this other person. All right. So, yes, I can give you every possible resource you could ever need. I am not presenting anyone on this list that I don't personally know somebody. In fact, there's a couple people in this room right now that I will introduce you to who are very good resources. And I will get to them too. Okay. Did that answer your question? Okay. All right. Advocate paralegal, now that we've beaten parent coach to death. Advocate paralegal. These are people who usually are not direct employees of your attorney, and you can hire them independently too. But often they'll work with your attorney. And what an advocate paralegal is someone who has a former career in education who then moved over to advocacy. Okay? You meet those all the time. Those are the people that I just told you about. Used to be a special ed teacher, went on to be a principal, superintendent, whatever, and then they finally switched sides and they became an advocate. Well, some of them go even a step further, and they decide to be what's called an advocate paralegal. Now, what does that mean? Well, they learn not only to help prepare IEPs, they learn to help prepare declarations and documents for court, for family court. And they are able to do it because they know what's going on in IEPs, and they know what's going on with special needs, and they've had sufficient exposure to the legal system, they know how to package it in a way that a court can digest it and get it. Your advocate, paralegal, and or your parent coach and your paralegal document preparer, they will help you organize your case. Let me tell you something. Once you get to court, an emergency hearing is maybe 5 minutes. Your first hearing is maybe 15 minutes. They'll say 20. They'll say even 40 sometimes. But plan on 15. And 15 minutes, if that sounds like it's insufficient, let me give you bad news. It's worse than that. The other side gets a turn too within that 15 minutes. Oh yeah, and then the judge has to digest it and make a ruling. So really, if you're lucky, you have 5. So how do you present a case in 5 minutes? Well, the answer is in advance. So you have thousands and thousands of documents at home. Your kid is thoroughly documented and reviewed and tested and assessed and all those things. How do you put before the court all the reasons why that all adds up to the court must pick a side and the court must pick you as that side? And the answer to that is you have someone help you organize it and tabulate it and get it to the point where it's not only on paper in a binder but also on a thumb drive and easily searchable, all in advance of the hearing. And that's still not enough, because all those documents are like the WikiLeaks dump before the election. Right? None of us knew what the email said until the media went through it and digested it for us and put it in searchable form. So on top of it all, you need a guide. And the guide needs to say, here's the story in a few pages, no more than 10, and hopefully only 2. And here's what all these thousands of pages say. Exhibit 1 is medical, Exhibit 2 is ABA, Exhibit 3 is this. And what's the good news about that? If you say under penalty of perjury what all these documents say, the fact that these documents are there, and there's nothing more fun than dumping that on the judge's desk, right? If you say they're all there, the judge will believe you for 2 reasons. One, the judge will spot check a few, right? A few. The other is the opposing party is not going to say, no, that's not true, because with a few spot checks, they destroy their credibility if they say it's not true. They may have a similar package, but it'll be much thinner, and it'll just be the regional center where the services were discontinued, or the school psychologist that said that the school's not going to give you services anymore, and it's going to be targeted and cherry-picked. You're going to have the whole picture and an explanation of why different people have different motives. And all of it will be there. And based on that, the court can make some temporary orders. And they may not be all the temporary orders you need, but at least it'll start the momentum moving in the correct direction. At that point, the court may panic and say, oh, I need to have a custody evaluation. And that's when you need your savvy attorney to say, you know, we have no qualified custody evaluators in San Diego County who know anything about special needs. Oh, well, what do I do? Well, you can order the custody evaluation, but make sure that they're consulting with someone who does have that expertise, or at least will contact all these experts that you see in my packet as collateral contacts. Okay. And then you have an opportunity to talk to an expert at length. But the other thing your savvy family law attorney will say, assuming the other side has endurance and doesn't want to give up, Your Honor, I need a trial of 7 days. All right, why is it good to do that? More to come. All right, once you're in court, put a pin in that. We're coming back to it. All right, so once you're in court, it is mandatory that you go to family court services. That's called mediation. Some of you have experience with it. That's a counselor who hopefully has a degree, who will be trying to get you to reach an agreement, and failing an agreement will make a recommendation as to custody and visitation. They will not read your thousands of pages. They will not read the court file. They will ask if there's any history of abuse. They will check CPS for records. They will check to see if anyone has a rap sheet. Other than that, they'll say, well, when do you go to work, and when do you go to work, and what's your proposal for visitation? Has there been any domestic violence? Is there a restraining order? Is there any documented alcohol abuse? Documented? Well, I documented it. It was on the news, actually. But was there any conviction for DUI? Was there an arrest for narcotics that resulted in a conviction? They're looking for what's called official truth. What's official truth? Official truth is truth that resulted in some sort of conclusion by some sort of government agency. That's official truth. And they don't care about anything else, because somewhere in their job, even though they probably got into the job because they wanted to help families, somewhere along the line they got institutionalized, and now they're just worried about not getting in trouble. And so if there's no official truth that disfavors one of the parties, they will tend to go for that joint custody, maximum contact sort of circumstance. So, if you can't bring in documents, and if they're not going to check documents, and they're not going to check collateral contacts, except maybe they'll contact the school, and maybe the school will contact them back, except maybe your relationship with the school isn't that good because you're in some sort of adversarial IEP situation. What do you do about family court services? Well, first of all, it is extremely helpful if you have someone who will prep you in advance as to how best present yourself under people under those unique and bizarre circumstances as I described. And I have someone in this room who actually makes that part of his profession. Is that all right if I say something about that? Do you mind being introduced?
No, not at all.
Okay. If you wouldn't mind standing up right now, I happen to know that there's a professional who does this very thing, and he's sitting here.
My name is Marus. I'm a licensed clinical social worker. I used to work at family court services. I no longer do. And I meet with people to explain the process for either family court services or private mediation.
So what does that mean? That means that you have somebody who can actually tell you in advance, if you get this question, don't get flustered. Here's how you answer. Here's what you say. I'm sure his advice generally be make sure your answers are truthful, but here's how you deal with it, and here's how you steer to topics that are important to you. Your family court services worker, by the way, the person who prepares you, Mr. Schlichtel would just introduce himself, is a very important part of your team. He's not a very good witness. He's not somebody you would put on the stand. The mediator might be. The mediator, if the mediator makes a recommendation in your favor, you're generally home free. There's actually a rule in San Diego that says the court can adopt or consider and adopt the recommendation without any foundation, and anyone who doesn't like that needs to explain their objection. That's a very, very strong local rule. Constitutionally, that's the US Constitution, the California Constitution, that rule probably has no legal force at all. Nevertheless, if you don't challenge it, that's the way it is, because path of least resistance. Okay? Now, if you challenge it, you win. And that's why the mediator is a very, very, very good witness, especially if the mediator is giving you an adverse recommendation. Now, what does adverse mean? Adverse can be as simple as sharing custody. That could be a very, very bad situation for your special needs kid. So, because the mediator was focused on relationships rather than on decision making, and does not understand how important the decision making aspect is with regards to special needs. So you put the mediator on the stand and you ask the mediator, did you review the court file? No. Well, you know, rule 5.120 says you're supposed to. I think it's 120, 5 point something. Yeah, but it wasn't available. Isn't your office in the courthouse? Well, yeah. Where does the file live? Never mind. I won't put you on the spot anymore, Mr. or Ms. Mediator. But did you review any of the documents presented by my client? Well, no, there were just too many. Well, how long was your mediation session? Half an hour. Half an hour? How long are your mediation sessions usually? Anywhere from 30 to 2 hours. Well, why did you only take 30 minutes? Well, the two parents were so obviously polars that I knew right away I'd have to make a recommendation. I didn't see any strong reasons for the objections of your client with regards to the other party's visitation. I thought the child benefited from time with both, and therefore I made the recommendation that I did. Okay, and you did that in 30 minutes. Like, well, I didn't think I needed any more. And did you take into account that the child had special needs? Well, I actually don't have any expertise in special needs counsel, but I didn't see how it mattered. I figured if both parties were involved, the child would benefit, and all the more if the child had special needs. Okay. All very good answers. By the way, all answers that I've heard many, 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 many times. And you're not there to humiliate family court services. By the way, if you're without an attorney, these are questions you would ask. And you're not there to humiliate them or show that they're wrong, just to show that they didn't base their decision on very much, their recommendation on very much. And what they did base it on was relationship-based, not decision-making based. And then, when you're all done with that, that's when you have other people who can explain what the documents that weren't reviewed meant, why decision-making is as important as it is, why, yes, it's true that it's good for the child to have a relationship with both parents, but with a child with this particular special needs, home basing is critical because you need to have a routine, you need to have continuity of care, they need to go to bed and then get up and go to school from the same place every day, or it's going to impact their academic performance. Okay, now that's not necessarily what the testimony will be in every single one of your cases, but you have testimony that explains that the issue is not one parent is, quote unquote, better than another, although one parent may be more likely to facilitate what the child needs. That's not the issue. The issue is, what does the child need? Give the child what the child needs. If that means that one parent's going to have less access time, hey, we're not about the parents' rights here. We're not. This isn't being fair to parents. Best interest of child. Okay. So I spent a lot of time on mediation. Why? Because it's mandatory. You'll have to go through it if you haven't already. And then once you've gone through it, you either got a great result or a bad result. You enhance your ability of a good result if you're properly prepped. If you get a bad result, even a bad result can be very, very, very useful, because then it becomes an opportunity to educate your judge as to why the judge should rule differently. I have told the judge many, many times, Your Honor, I need 7 days. Counsel, why do you need 7 days? We have a recommendation. That's why. The recommendation is against the position of my client, and it's wrong. I'll need time to prove it. And Your Honor, your own skepticism tells me that I need more time to show you why it's wrong. Now, Your Honor, if you said, hey, I don't care about these kinds of recommendations and they don't influence me at all, and actually I already feel from these records that your client is right, Mr. Marcus, I wouldn't need 7 days. But the fact that you're already feeling skeptical means you need the whole story. Now, after you have the whole story, if you still feel the same, fine, but I need time to give you the whole story. And I already showed you, boom, how much of a story there is. And I'm telling you it's all important because it wouldn't have been generated otherwise. I didn't generate those thousands of pages. Psychologists did, or ABA assessors did, or whatever people did. They did it for the benefit of these kids. If that information was generated, it's entitled to review. It has importance. All right. CWS. Some of you will know CWS is CPS, Child Protective Services. Don't be fooled by the name. I don't know why they're called that.
Make it funnier.
Child Welfare Services. That sounds like the people you would call if your child was in danger, if your child was being abused, right? Those are the people you think you would call. Some people in here are mandatory reporters. What's a mandatory reporter? It's a crime not to report abuse to these people. I'm a mandatory reporter. I have 3 teaching credentials. I'm a school teacher as well as being an attorney. I don't report. Take me to jail. I don't report. And why not? There have been some studies on human behavior. And even the best of us, and by the way, this room contains the best of us. I mean, I can say without too much concern about being contradicted, the people who have the strongest impulses tend to come to classes like this. Even the best of us, if we are not constantly in the check and balance environment of our peers, will give in to our worst, evilest impulses at times. I don't know why it is, just a truth of human behavior. That's why you got to be plugged into community. Your community keeps you right. Your community reminds you of what your values are. There is something about being unsupervised that leads you into evil and temptation. And I'm not preaching religion here because that's not an issue of religion. It's an issue of psychology. And it's hard to believe, people who believe like they have an intrinsic soul or moral compass, how easy it is for something like that to happen, but the studies exist. So why do I tell you about this? CWS is an unsupervised, for the most part, organization. They are secret. And the reason they're secret is to preserve the privacy of children, because they want to protect the children from shame. They want to protect all these lurid details of what's going on with the child from the outside world. They think they're protecting kids with this. They are not. Kids to some degree are concerned about shame, but I guarantee you they're more concerned about safety. And one of the problems with having this unsupervised situation is that CWS will lead to all kinds of bizarre outcomes. And let me see if I have enough time to even give you one example. I'm not sure I do. I do. No, I don't. I don't. Not if I'm going to let you have questions. But the bottom line is that it's private, it's clandestine. You don't know what they're going to do. Even if you think the opposing party is doing terrible things to your child, there are other mechanisms other than CWS. CWS is your last resort. Call the cops. Cops will tell you, well, I have to call CWS. I'm a mandatory reporter. It's like, fine, I'll live with that reality, but at least you have a video camera on your vest and you are subject to public scrutiny and all right. All right, probation investigator. If the court is understanding that a bunch of things are happening in your case and may want to send someone to do a home visit or whatever, that's to be discouraged. Why? Again, this person is going to be looking for somebody doing wrong. This person is not even equipped on the relationship side, and they're certainly not going to look on decision-making and special needs. They're there to see if the food in the fridge, dirt in the house. They're not going to be helpful, and it's a useless expense, and it's a useless consumption of time. All right, now we've gotten to the judge. You will have a judge who's assigned to you for all purposes. That's your departmental judge. This is your student of one for the short hearings. The minute you say that your ultimate trial is going to take more than 2 days, that judge will say, I don't have time. You're going on what's called the wheel. The wheel is 2 other judges that do nothing but take trial after trial after trial. So the cool thing is now you've gotten yourself out of that court, that place where the judge is just getting a zillion cases and has to decide them all at once, and you're now in the court where a judge is going to decide on the facts. The problem is your week-long trial is not going to be heard for a year. That's the problem. So you have to find a way to manage your case where the immediate issues that arise can be dealt with by your department judge while nevertheless conserving the long cause date, because that's when you're going to finally prove your point all the way through. The third judge I have there is the juvenile judge. That is the person who will oversee whatever situation has arisen out of CWS. So based on what I told you, you really don't want to be there, and if you are there, you want to get out as quickly as possible. Once again, that whole process is secret, it's confidential, and it's subject to problems. And it's got so many people involved, so many attorneys representing different interests, that you essentially just lose control. Your family law attorney should be able to know the ins and outs of that. If you're stuck in that system, they should know how to get you out. The most important thing I need to tell you about CWS and the juvenile system is if you are the subject of a CWS investigation, and by subject, I don't even mean that you're the accused, right? They think the other person has beaten somebody or whatever, right? And they want to talk to you. Don't talk to them without your lawyer. If you haven't had a lawyer up until now, get one for just that. And you're thinking, but they're not investigating me. They're investigating the opposing party beat up my child. Why would I worry about that? And I will tell you, I've had so many cases where my innocent client lost custody because the worker decided that you put the child up to making the report, that it's a case of alienation, and therefore we must put the child with the abuser. I can think off the top of my head of 3 cases where that happened. So it's much less likely to happen is when they talk to you, you have your attorney there. Now, a lot of times they'll say, well, it's our policy not to talk to parties with attorneys. Well, it's my policy to talk with my attorney there. Well, you're not being cooperative with the investigation. I'm very sorry you feel that way. Okay? Now, will they go to court and say you weren't cooperative? Absolutely. And that's when your attorney says, oh no, here's all the letters where I tried to set up the interview. My client said they were trying to get a hold of my client, and I called the department and wanted to set it up, and they said it wasn't their policy. They don't like talking to witnesses who have counsel. And the court would be like, is that true? That's your policy? Do you prefer unrepresented people who are not advised as to their legal rights? And why would that be? All right. I've actually had several cases where the court made findings that CWS acted against the best interests of the children, and a couple were found that CWS was abusive. But those kind of findings only happen with counsel. They never happen. Now, the good news about juvenile court is they will provide counsel for free, and that's about what the attorneys are worth. Not because of their skills. They may be very skilled, but they're also part of the system, and there's something that happens when you become part of that system. Okay. Private mediators. The other party may want to invite you into a private mediation in the collaborative system. Now, what's a collaborative system? That's where everyone wants to stay out of court. That sounds really good. Everyone wants to stay out of court, and we just work together. Okay? Work together usually is code for, let me put you in a place where evidence doesn't matter and I can just bully you. And you're being unreasonable if you disagree with me. So the collaborative system has gotten a lot of good press, not in this room. Not in this room. And that's because in a case with special needs, there is no haggling and there is no compromise. There is no haggling and there is no compromise. Your child needs what your child needs. And if your child needs what your child needs, then it's not like, well, how about if your child gets what your child needs only on alternate Thursdays? Until we have a situation where both parties buy into what the child needs, then you can talk, sure. But if the fundamental issue is, does the child need anything, there's nothing to talk about in the collaborative session. All right, private mediation recommending. Private mediation recommending is exactly like FCS, only longer and more expensive. It also requires prep. They may actually review your documents, so that's a good thing. On the other hand, let me tell you where it's bad, where they review your documents just enough to reach the wrong conclusion. And now when you put them on the stand, they say, yes, I did review everything and came to the wrong conclusion. So in many ways, a private evaluator is actually a problem. Unless you are really sure that they know something and they have a reputation in this area and they understand special needs, great. But if they don't have an expertise themselves and they're just kind of sifting through what other people tell them while two parties are telling them two different stories, it's very dangerous. And frankly, I haven't had it work out once. But they have been very expensive. All right, child custody evaluators, I already talked about. Parenting plan facilitator. Often an evaluator, I said I was going to get to this. Often an evaluator will recommend and a court will adopt, unless you object, to a parent coordinator. Now, what's a parent coordinator? The judge is like this, I am getting so much information and I cannot decide who is right. And these parties can't communicate, despite, I recognize you have a parent coach and you do not, but these parties need someone to work it out between them and to make decisions if the two parties can't. In other words, a substitute parent who also will know nothing about special needs. It'll usually be some well-known psychologist who charges anywhere up to, I know one who charges $520 an hour. And they are essentially, well, they come in two flavors. They are either confidential mediators. They try to get you to agree, and if they don't, no one knows, but you don't get anywhere and you're out a lot of money. Or they're non-confidential referees, in which case if you can't agree, then they either make the decision for you or they make a recommendation to the court to make the decision for you. So here's the good news. If you raise your hand and say, Your Honor, don't order it, I object. It's not legal. You have no jurisdiction to order that over my objection. You are correct. And if you say that, the court can't do it. So that's the good news. The bad news is a lot of people don't know that. And they say, well, the child custody evaluator recommended it. And the court will say, do you have any objections? And you're like, So just so you know, no. Don't be afraid to say, you know what? No, there's just only one right person here. Only one person who matters is the child, who has needs that must be addressed, period. Your Honor, if you don't have enough information to make the decision, we need another day. We need 2 more days. You will get enough information, and you will make this decision. Code of Civil Procedure 170 says a judge must resolve matters before it. Do all attorneys know that? No. Do all judges know that? No. Do they like being confronted with it? Not always. But sometimes it's kind of fun when your attorney says, Your Honor, you can't kick this down the road. If you've had insufficient evidence, let's get you more evidence. Period. And when we're done, you'll know who the right person is. All right, that's the parenting plan facilitator and the parenting coordinator, and the difference between confidential, binding, and non-binding. Okay, let's see how much time we have left. We have 7 minutes left. Is that correct? Madam Monitor? 5 minutes. There we go. Sorry. I had it in that corner this time. I missed you. Sorry. All right. All right. So I ran through this so quickly, and I know that you probably didn't, or maybe you got it all, and you guys are that good, and you've managed to sift through my rambling in a way that requires no questions at all. But if there's no questions, I do have more to say, but if there are some questions, I want to answer them. Oh, let me introduce one more person, if that's okay. Okay. So a lot of times, once the court reaches a conclusion, it'll determine that, all right, fine, you forced me to make a decision. You're going to be the decision maker. You're going to have custody. But I really feel concerned about leaving one person out, and I really want to facilitate this other person's involvement, which means go to school, learn how to make the right decisions. In the meantime, there may be restrictions on access or direction on where they can get more information. And a lot of times that will be facilitated by someone that the court trusts, that is not necessarily all the witnesses you brought, your psychologist or your ABA person, or all these people who are in home. It'll be someone that the court trusts to kind of coordinate assisting the parent who quote unquote lost, because the judge doesn't want anyone to lose and wants all parents to be involved. Once the court's made that decision, the court may get somebody involved, such as Susan Griffin, who has a number of programs ranging from monitoring rehabilitation of relationships for targeted parents, parents who have had their attachments disrupted, to I'm sorry, I probably shouldn't speak for you, but people who need supervised visitation until they can develop skills and distance themselves from conflict sufficiently that they can focus on what's best for a child. What else?
We have a full range, 100% of our programs are for family court families. And so we have a program called Two Home Kids, which is the visitation exchange in-house, agency-based. We have Bridges, which is community or home-based visitation and exchange. And then we have a full-service therapy program. Everything, we're a nonprofit, everything on a sliding fee scale. And we have all of the educational, psychoeducational programs that you can imagine, high conflict couples therapy for co-parents who are struggling with the kind of orders we were talking about, direct legal custody, and it's impossible. And we do a lot of conjoint therapy, both with situations where there's joint custody but also sole custody, and then we also do conjoint therapy in estrangement cases. And we have a special program for that called the Intensive Family Restructuring Program, and several other things we can talk to.
Now, one of the things that's really important that one of the important things that she has not mentioned deals with the very first member of your team that I mentioned, which was, which was you. So I know Susan has some programs that actually are, that are
free support groups.
Yeah, keep your head together, keep you focused, keep you healthy, keep you knowing you're not alone and you're not crazy. So there are people out there, and I just heard free, so I like that price. All right. So, any questions? Yes.
Is the only way to get like the therapist in there is by subpoenaing them? Like, 'cause I had trouble getting like the therapist to come to court or do decorations. It seemed like the only way to get in there.
Well, subpoenas work.
Some other maybe.
No, there's no other way.
Okay.
I mean, well, there's no other way that's good. I mean, you could bribe them to come, but then someone will say, "Why are you here?" Well, I got a ton of money to say good things. So subpoenas are really good because it lends credibility to your witness if they came because they had to. Okay, now they'll charge you a fee. Those of you who don't have attorneys don't have subpoena power. I just had a case 2 days ago where the self-represented litigant says, "We've come to court twice, I've subpoenaed witnesses, they haven't come either time. Your Honor, what are you going to do about it?" And the court said nothing because the court can't give legal advice. But the fact is, non-attorneys don't have subpoena power. So you can sign subpoenas all day, they don't have to come because you're not an officer of the court. That doesn't mean that even without counsel you can't get people to come. You go to court, there's actual judicial officers that sign your subpoenas for you. They do have that power. And so you can get a subpoena signed even if you're not represented. And your facilitator, if you're willing to wait at 7:30 in the morning and you have no money, will help you with that. Okay. So there's that. Now the therapist may say, here's a problem with therapists. A lot of times the other parent will say, "I'm invoking the privilege. Whatever the child told the therapist is confidential and I'm not giving up the privilege." Well, now we have the cart before the horse, right? The very reason you're there is to deal with legal custody. The court hasn't taken legal custody away from the other person, and now the person is saying, "I don't want the therapist talking." All right, well, there's two things that can happen there. One is you can persuade the court that the other parent doesn't have the privilege. Most judges don't buy that. The next thing you can do is ask that an attorney for the child be appointed. I hate that option. Most attorneys for children only cause trouble. Hate to say it, but it's true. But they can deal with the privilege issue, and you can ask that they only deal with the privilege issue. The last thing, which is the most fun and which I do almost all the time, and it's usually enough, is I just ask the court to remember who didn't want to hear from the child. Okay, so now the therapist has never testified and you saved all that testimony time and all that expense, but just remember who wanted the child heard from and who didn't. And maybe your point is made right there. Go ahead.
Yes, I'm a foster mom. I'm a paternal grandmother, and I've been having trouble with my family. It's about a will in Mexico that they want me to sign and everything, so I'm just waiting. But every time they get mad, they call CPS.
Yes? Is there a question in that?
So CPS come to my home and treat me like a criminal.
Yes.
It's really sad because they like they push me like, "Oh, you need to come right now with me and do a drug test," because they call and say that I was a drug dealer and I sell drugs and all that. It's that normal or?
Yes.
So that's okay?
I know, I didn't say it was okay.
Do I have any rights? Because everything is.
Yes, you should not be talking to them without your attorney because they will do that. And in fact, what a time you'll say, well, let me give you the number of my attorney. And like I said, even if you can't afford an attorney for anything else, get an attorney for that. Because now we're talking about possibility of losing control of your child possibly for 18 months or more. So they are extremely dangerous. And I won't say that they aren't sometimes a force for good. I have a brother who adopted a child through the CWS system, and I love my niece. Okay, but it's something that's so uncontrollable and so unpredictable that it's dangerous. Just because there will be so many good stories. There may even be more good stories than bad stories, but frankly, there are just too many bad stories. That's the bottom line. There's just too many bad stories. So yes, and they're trained to do exactly what you experienced, to try to prevent you from talking to them when you're in your comfort zone, preventing you from having counsel present. If you say, I want my counsel present, they'll say things, well, I just have a quick question. You're not a suspect. I just need to clear your name really quickly. They'll say all kinds of things, but ultimately they have no right to come on your premises without a warrant. They have no right to speak to you unless they have, unless you're detained for some reason, like the cops arrested you. And even then you have a right to an attorney there. So yes, what you were exposed to is normal. Is it right? No, I don't think it's right.
Yeah, because
But I'm not here to reform CWS. I'm just here to give you the news.